Cyberspace is a domain without distinct borders, where action at a distance is the new reality. In effect, almost every computer in America is a potential border entry point. This reality makes international engagement on cybersecurity essential. Even more notably, the sheer scale of the network demands a global approach. The Internet is as large a human enterprise as has ever been created. More than 2.5 billion users send more than 88 quadrillion emails annually. Of course, most of that is spam, but still, that's an immense number. And register a new domain name with the Internet Corporation for Assigned Names and Numbers, also known as ICANN, every second of every day. The scope of the Internet is as broad as the globe, and that makes the scope of the Internet governance question equally broad. Who sets the rules for the Internet, and what rules they set is a question that can only be answered on an international basis. This, then, is a fundamental question, perhaps even the fundamental question of cybersecurity today. How should a fractured international community respond to the phenomenon of the network? In this lecture, we're going to look at the international responses. We will start by talking about the existing Internet governance and describe the dynamic that is leading to change. Then we will assess some of the barriers to effective international Internet governance. And by the end, I think you'll agree that the current structure, with all of its flaws, is likely better than any of the alternatives. Let me start with a cybersecurity scenario that shows you what makes cyberspace so inherently international. Let's assume that you've thought long and hard about our last lecture on regulation, and you've decided that a regulatory system is necessary. That's hardly the end of the story, because that's only for America. Much of American critical infrastructure is interconnected with international counterparts. For example, our electric grids are actually aligned vertically, so that Eastern Canada and the Eastern United States are like a joint operation. Likewise in the West. Texas, as always, goes its own way. When the Great Northeast Blackout happened in 2003, its effects rolled up from Ohio into Ontario and then back into Michigan, recognizing no border at all. As we've already seen, the vulnerability of the electric grid is one of the principal factors driving cybersecurity concerns. The SCADA systems that control the grid are considered highly vulnerable. Indeed, in March 2012, a U.S. Senate cyber exercise involved a simulated attack on the electric grid in New York City. But New York's retail electricity provider, Con Edison, gets a lot of its electricity from Canadian companies like Hydro-Quebec. How stupid would America feel if, say, the following events took place? The NSA, through sources and methods, uncovers a significant SCADA vulnerability. Using the newly promulgated authorities of the sort being considered for implementation in America, NSA shares that information with Con Edison, who spends significant resources patching the vulnerability. 6 months later, the lights go out in New York because a malicious actor exploits a nearly identical vulnerability in the SCADA system at Hydro-Quebec, causing a cascading blackout in the entire Northeast corridor. Nobody ever told Hydro-Quebec about the vulnerability. And this information sharing hypothetical can be broadened to a regulatory hypothetical. How useful is it for the U.S. Department of Homeland Security to promulgate new security standards for U.S. critical infrastructure if Canada doesn't follow suit? At a minimum, should Canadian companies be part of the conversation? And if that's true for Canadian power generation, what other critical systems are international in nature? So with that in mind, let's step back a bit and get a historical perspective. One has the clear sense that in the 1970s, when the Internet was born, the various sovereign nations of the world really didn't think much about the innovation. By and large, they systematically ignored it, and they let it grow on its own with only relatively unstructured sets of governing authority. And then, sometime around the turn of the century, the nations of the world suddenly looked up and recognized that the internet had become this immense entity, possibly the largest human enterprise in existence, and that it had a vast influence and power. The internet could be used to change governments or spread culture. It could run nuclear power plants and fight wars. With that realization, sovereign nations became quickly and intensely interested in the internet. The result is a trend towards the re-sovereignization of cyberspace, or what Chris Demchak and Pete Dombrowski of the U.S. Naval College call the rise of a cybered Westphalian age. That is, an age in which nations, sovereign nations, regain control of the internet. The reference, of course, is to the Peace of Westphalia in 1648, which more or less defines our current system of nation-state international governance. And so the question is, who, if anyone, should control the internet? Will it be separate sovereign nations? Will it be the UN? Or non-governmental organizations like ICANN? Or perhaps a series of binational or multilateral groups? For America, this question poses a real challenge. Some think it is critical that we protect American interests and maintain American freedom of action. By contrast, others favor the development of multilateral norms that preserve the openness of the internet while relying on supranational organizations like treaty groups or the UN to manage cybersecurity problems. The choice is of truly profound significance, perhaps more so than any other question to be addressed in the cyber domain. In one direction may lie authoritarian state control. In another, chaos, where bad actors reign. Can we perhaps find a way to thread the needle and manage to maximize both security and freedom without severely compromising either? Today's internet is controlled, to the extent anyone can be said to control it, by non-governmental organizations, or NGOs. We've already talked about one organization that is partly in charge of a portion of the internet. Back in the lecture on identity, we discussed the Internet Corporation for Assigned Names and Numbers, or ICANN. ICANN is a nonprofit organization that sets the rules for creating and distributing domain names. Today, ICANN has a global constituency, registering new domain names every day. You will recall, however, that some think that it's an American creation, and they don't trust it. Just as ICANN is the international organization that runs the program for assigning domain names, another non-governmental organization, the Internet Engineering Task Force, or IETF, is responsible, in an indirect way, for developing the technical aspects of the computer code and protocols that drive the internet. In other words, the actual rules for how the cyber domain works are set by the IETF, which is an open international community of network designers, operators, vendors, and researchers, all concerned with the evolution of the internet's architecture and the smooth operation of the internet. This community sets the technical standards, which in the end become the de facto operating requirements for any activity in cyberspace. Put another way, the IETF's self-described mission is to, quote, make the internet work better. But it quickly notes that it's an engineering group. So what it means by better is more technically effective, not better in some metaphysical sense. The IETF is a self-organized group that considers technical specifications for the internet. Anyone may join, even you. And the group's proposals, or decisions not to make proposals, are the product of a rough consensus. The IETF has no enforcement function at all. Anyone is free to disregard the technical standards it sets. But they do so at their own peril. Because of the openness, inclusiveness, and nonpartisan nature of its endeavors, IETF standards are, or have become, the gold standard for internet engineering. In addition to the standard-setting function, IATF also identifies lesser standards, known as best current practices, that are more in the nature of good advice than operating requirements. Given the near universality of IATF standards and practices, anyone who chooses not to follow the standards risks ineffective connection to the broader network. And so, even without a single means of forcing people to follow its dictates, the IETF in effect sets the rules of the road for the Internet's technical functions. The international regime of NGO Internet governments works pretty effectively, but there are some who doubt its neutrality. Others worry that an NGO system is a threat to nation-state power. For example, despite requests from several countries, the IETF has refused to set an encryption standard for Internet traffic that would help governments monitor criminal or subversive Internet traffic. This has led sovereign nations to think of ways to reassert their authority. So let's consider 4 non-NGO alternatives to Internet governance: isolation, international competition, multilateral agreements, and an international organization. As we'll soon see, none of them is particularly attractive, leaving many, including me, to think that the status quo of NGO control is the least bad alternative. One method that some countries have chosen is isolation, to attempt to cut themselves off from the Internet or censor traffic arriving at their cyber borders. The most notorious example is China's attempt to construct a Great Firewall to keep Internet traffic out of the country. China conducts an active effort to suppress adverse news on the Internet, with more than 300,000 Internet monitors engaged in the process. These monitors closely watch domestic postings on chat rooms and Twitter accounts, and quickly update the government's data screening programs to intercept information. For example, a search for the words Tiananmen Square on Google from a computer in China will simply return a null result. News of pro-democracy movements outside of China is also suppressed. And in late 2012, when the New York Times reported on the extraordinary wealth of some of China's rulers, that information too was blocked from the general population. As a result of some of this, the recent unrest in the Middle East seems to be unable to find traction in China. The instinct to regulate is not, however, limited to authoritarian regimes. Even liberal Western countries like Australia have proposed restrictions on Internet traffic, albeit for reasons that some people would find more legitimate, like limiting the spread of child pornography. Or consider another example of isolation, this from a relatively small nation, Belarus. According to the U.S. Library of Congress, on December 21, 2011, the Republic of Belarus published Law number 317-3. The law imposes restrictions on visiting and/or using foreign websites by Belarusian citizens and residents, enforced by the Belarus Internet Service providers. It also requires that all companies and individuals who are registered as entrepreneurs in Belarus use only domestic Internet domains for providing online services, conducting sales, or even exchanging email messages. In addition, the owners and administrators of Internet cafes or other places that offer access to the Internet might be found guilty of violating this law and fined, and their businesses might be closed if users of Internet services provided by those places are found visiting websites located outside of Belarus. And if such behavior of the clients was not properly identified, recorded, and reported to the authorities. Boy, talk about a Westphalian response to the borderless Internet. Now, instead of the isolation approach, we might leave the governance of the Internet to the nations of the world to sort out in competition with one another. But when nation-states get into the act, their institutional interests often lead to conflict rather than cooperation. Even Western nations sometimes wind up in conflict because they can't agree on the right course of action. One of the best examples of this is the critical issue identified by the phrase data sovereignty. At its core, the question is, whose law controls the data that is accessed and transmitted via the internet? Answering that question is a pretty significant challenge. The question of control is not a new one. Issues of data sovereignty have been around since the first bits and bytes of data were transferred to cheaper offshore data storage facilities. But the transition to a broader internet-based model has greatly exacerbated the problem. When a customer uses cloud data storage, that is, storing his data on a server in the internet rather than on his own laptop, he outsources data storage requirements to a third party. The service provider owns the equipment and is responsible for housing, running, and maintaining it. And those servers can be anywhere, in the United States, in Europe, in Russia, or in a smaller third world country. When the customer is a private sector company, the transition to this cloud storage and processing services model creates difficult jurisdictional issues. Whose law is to be applied? The law of the country where the customer created the data? The law of the country, or several countries, where the servers are maintained? Or the law of the home country, where the data storage provider is headquartered? At a minimum, customers need to exercise caution and get concrete legal advice before transferring any data offshore. There is, today, no international standard that governs the question of data sovereignty. Nor is any institution, like, say, the United Nations, likely to sponsor an agreement of this nature in the near future. Rather, disputes about the control of data are resolved on a case-by-case basis, often turning on geography and/or economic factors that underlie the problem. The fundamental factor that is likely to determine the resolution of a dispute is the physical location of the server. Let's take two recent examples as a way of making that theoretical discussion seem more concrete. In one case, the United States began demanding that Swiss banks provide it information on American overseas accounts to be used for enhanced tax collection purposes. Because the Swiss banks had to have a physical presence in the United States in order to be effective in the international financial marketplace, they had to yield to American law. In the other case, when American Treasury officials sought bank transaction information in order to track terrorist finances around the globe, they were denied access to that information. Why? Because there, the data was located on servers in Belgium, where European law applied. The lesson here is that the internet has a real-world physical presence with its fiber optic transmission lines and server farms. Every data storage facility is located somewhere. And when that somewhere is not in the United States, American companies run the risk that the data stored overseas will be subject to the sovereign control of the country where the data is located. That's probably tolerable and manageable for a private company, but maybe not for the US government. Should our tax data be stored overseas, for example? And for individuals like you who use cloud services, you don't really have a choice. If you use a cloud provider like Google for your email, you have no real idea where your data is. Perhaps that won't matter to you, but someday it might. Your data could wind up in a tug of war between two or more competing countries, and you may have no say at all in who ultimately gets control over it. But if internet governance via international competition seems unappealing, the prospects for a multilateral response are no more promising. Consider how the multilateral impulse has begun to drive negotiations over a cyber warfare convention. For years, the United States resisted Russian blandishments to begin negotiations over a cyber warfare convention akin to the chemical warfare convention. The Russian model would outlaw certain types of cyber attacks, say on civilian targets like the electric grid. At its core, this seems like a reasonable objective. The principal American objection has been that a cyber treaty, unlike, say, a ballistic missile treaty, is inherently unverifiable. In other words, in a world where weapons cannot be identified and counted, and where attribution is difficult, if not impossible, how could any country be assured that others were abiding by the terms of the agreement? Beyond verifiability, there is also a question of enforceability. Those who are skeptics of a cyber warfare convention point, for example, to the provisions of the 1899 Hague Convention, which prohibited the aerial bombardment of civilian targets. We know how well that worked out. The commitment to withhold bombing of civilian targets did not survive the World War II Blitz of London or the firebombing of Dresden, not to mention the nuclear targeting of Hiroshima and Nagasaki. There's therefore good reason to doubt that a prohibition on targeting, say, electric grids would be actually sustainable in a truly significant conflict. One interesting note is to contrast the Russian eagerness for a cyber war treaty with their unwillingness to negotiate over a cyber crime treaty. The political realist in me sees this as perfectly understandable. Russia benefits from having an unregulated criminal element to which it can turn for cyber assistance in times of crisis, as they did in the Russia-Georgia war, which we discussed in Lecture 8. But they would benefit from a cyber war treaty because it might restrain the growth of American cyber power that they fear. Now, notwithstanding these concerns, in 2009, the United States abandoned its position and agreed to discussions with Russia and other leading cyber nations under the auspices of a UN group of experts. Now, so far, little has come of those conversations. The principal reason for this lack of progress is that the proposed treaty comes with some additional baggage, because many of the other nations of the world see the domain of cyber conflict as much broader than we do here in the West. Non-Western states view the cyber domain less as a means of communication and more as a means of control, a viewpoint they want to import into any global treaty that might be adopted. Consider the International Information Security Agreement that's been written between the Shanghai Cooperation Organization nations. That's China, Kazakhstan, Kyrgyzstan, Russia, Tajikistan, and Uzbekistan. Under that agreement, state security and state control over information technologies and threats is permitted. In the view of these SCO nations, the major threats to their own sovereignty are the dominant position in the information space of Western nations and the, quote, dissemination of information harmful to the social political systems as well as spiritual, moral, and cultural spheres of other states, end quote. In other words, they want to enshrine cyber censorship as an approved practice under international law. Let's pause here for a moment and think about censorship and internet freedom. The United States' position on internet freedom has been somewhat conflicted. After all, freedom to use the internet for political purposes often comes at the cost of decreased security on the network. But by and large, we've come to see freedom of expression on the internet as a fundamental good. That's why Secretary of State Hillary Clinton emphasized that, quote, those who disrupt the free flow of information in our society or any other pose a threat to our economy, our government, and our civil society. Indeed, as a symbol of our view that freedom of expression is critical, the United States is actually leading efforts to develop the technology for a shadow internet, one that can be deployed independent of the main backbone of the network. What it is, essentially, is a technical means of allowing users to bypass the landline and fiber optic backbone of the network and connect directly to it via satellite connections. These types of connections are significantly harder to block. This new technology would, in effect, create an internet in a suitcase, and it would enable dissidents to avoid the censorship of repressive authoritarian countries. So what do you think? Do human beings have a fundamental right to have access to the internet? How you view the question may very well drive your assessment of the right structure for the international governance of the internet. Indeed, if you think access is a fundamental right, you'll be unalterably opposed to the new cybered Westphalia. Vinton G. Cerf thinks that the answer is clearly no. People don't have a right to internet access. And he ought to know. After all, Cerf is one of the famous fathers of the internet and currently serves as the chief internet evangelist for Google. He is one of the grand old men of the network, if any endeavor that is as young as the internet can be said to have grand old men. According to Cerf, the right way to think about technology is as an enabler of rights, not as the right itself. Human rights, he says, quote, must be among the things we as humans need in order to lead healthy, meaningful lives, like freedom from torture or freedom of conscience. It is a mistake to place any particular technology in this exalted category, since over time we will end up valuing the wrong things. After all, 150 years ago, having a horse might have been an essential enabler. 50 years ago, a car. The internet, like any technology, is a means to an end, Cerf maintains, not the end itself. But others disagree. For example, the United Nations Special Rapporteur on the Promotion and Protection of the Right to Freedom of Opinion and Expression is of the view that a complete denial of access to the internet is a violation of international law. Quote, cutting off users from internet access, regardless of the justification provided, is disproportionate and thus a violation of the International Covenant on Civil and Political Rights. End quote. The rapporteur views the denial of internet access as an unacceptable means of controlling freedom of expression and limiting dissent. Set against the backdrop of the Arab Spring, there's a certain force to his concerns. So, if the Westphalian model leads to conflict, and if the multilateral model involves disagreements over fundamental values that can't be squared, why not go whole hog and create an international institution to run the internet? Alas, that option too is problematic. As we've said, the architecture of the internet has been defined for years by two NGO organizations, the IETF and ICANN. Both are nonpartisan and professional, but their policymaking is highly influenced by nations that are technologically reliant on the internet and have contributed the most to its development and growth. In other words, one reason the internet is the way it is because of who its parents are, so to speak. In essence, liberal Western democracies. As a consequence, America has an influential role in those organizations. Consider, for example, the wish of some non-Western nations to enshrine cyber censorship in international law. Reflecting back, this is one of the reasons that some national governments see NGO control of the internet as a threat. The IETF is very unlikely to adopt technical standards to allow the easy implementation of a censorship regime, something that authoritarian nations very much want to see built into the internet. Many in the world see Western influence over IETF and ICANN as problematic. The International Telecommunication Union, or ITU, which dates back to 1865 but is now a part of the UN, has been proposed as a better model for internet governance. Transferring authority to the ITU, or a similar organization, is seen as a means of opening up the control of the internet into a more conventional international process that dismantles what some see as the current position of global dominance of U.S. national interests. In the ITU, like most United Nations institutions, a one nation, one vote rule applies, a prospect that would certainly diminish Western influence on internet governance. Indeed, some argue that giving the ITU a role in internet governance is no different from the role that the World Customs Organization has in setting shipping standards, or the International Civil Aviation Organization has in setting aviation traffic rules. To some degree, that may be true. On the other hand, aviation communication frequency requirements and standard shipping container sizes are not fraught with political significance in the same way that the internet has become. Rather, those institutions succeed precisely because they manage the mundane technical aspects of a highly specialized industry. They would be ill-suited to provide broadly applicable content regulation for a world-girding communication system of the sort that China and the SCO countries would advocate. To be sure, it might be theoretically feasible for the ITU to restrict itself to technical questions of the sort the IETF addresses, but as we've already seen, those technical questions of encryption, attribution, and content blocking are riddled with political implications. That's why some fear that a transition to the ITU would run the risk of politicizing an already contentious domain even further. At bottom, however, the preference for ICANN over the ITU is not just about national interests. It's also, more fundamentally, about the contrast between ICANN's general adherence to a deregulated market-driven approach and the turgid, ineffective process of the international public regulatory sector. Recall our discussion in the last lecture about the challenges from the slow pace of American regulatory and policy apparatus. The problem will, if anything, be exacerbated in the international sphere. Given the scale of the problem, it is likely that the mechanisms for multinational cooperation are too cumbersome, hierarchical, and slow to be of much use in the development of international standards. Acceptable behavior on the internet mutates across multiple dimensions at a pace that far outstrips the speed of the policy-making apparatus within the US government already, and the international system is immeasurably slower. Indeed, some are reasonably concerned that there is no surer way to kill the economic value of the internet than to let the UN run it. And so, though there is a real intellectual appeal to the idea of an international governance system to manage an international entity like the internet, the prognosis of a cyber Westphalian age, lightly controlled by NGOs such as ICANN and IETF, is almost certainly the more realistic. We are likely to see the United States make common cause with trustworthy allies and friends around the globe to establish cooperative mechanisms that yield strong standards of conduct while forging engagement with multilateral organizations and authoritarian sovereigns. This doesn't mean, however, that there won't be conflicts over control of the internet in the years ahead. Fundamentally, the West, along with ICANN and the IETF, is committed to the rule of law, broadly understood as fostering freedom within the structure of ordered liberty. Other institutions, authoritarian governments, and maybe the ITU, where the authoritarian governments will have a voting majority, are more about the law of rules, that is, about asserting sovereign affirmative control of the cyber domain. And standing against both of those groups are non-state actors who are dedicated to a more unstructured, chaotic view of the world. Some, like the happy ninjas we talked about, might be forces of good and backers of pure internet freedom. Other, more destructive actors, like Anonymous or LulzSec, are much more anarchistic in their intent. We can be reasonably sure that these groups will, over the next years, contest for control of the internet domain. As I said, the international dimension of cybersecurity is a puzzle without an easy answer. None of the options seems terribly satisfying. For now, however, I think we can be reasonably content. The NGO system run by the IETF and ICANN seems to work reasonably well. So perhaps the best answer is, if it ain't broke, don't fix it. I look forward to talking with you in our next lecture, when we will return our attention to the United States and start talking about the internet and the US Constitution. We'll look at what the government is, isn't, should, and shouldn't be doing in cyberspace. So in the last two lectures, we have basically asked whether or not the government can and should regulate the security of the cyber domain. We first asked how the US government might do the job, and then in the last lecture, we asked about the possibility of international regulation. In this lecture, we're going to shift the focus slightly to a different question. We're going to return our attention to America and ask not about government regulation, but about the idea of government control and protection. After all, one of the goals of the Constitution is the creation of government to provide for the common defense. We might say that the federal government is also responsible for defending cyberspace. We don't expect every manufacturing plant to have anti-aircraft guns, so why do we expect every cyber facility to have the cyber equivalent? And we do expect the police to patrol the streets and provide us with protection against murder and robbery. So shouldn't the government be patrolling for us the internet network and protecting us against attack there? I assume you can see some of the problems with that idea right away. If the government is on the network monitoring it for malicious activity, then the government is on the network monitoring it. That might be a good thing, but in America, we have a healthy skepticism of government surveillance. We don't have the government routinely watching our conduct because we don't want the government knowing all our business. If the monitoring is for illegal malicious activity, well, then it could also be for political activity, can't it? Well, whether you realize it or not, government monitoring of the internet is already a fact. So in this lecture, we have two goals. First, I want to briefly talk to you about how the on-network monitoring systems work. Then I want to step back a bit and tell you about how government monitoring is governed by laws, and particularly how it is limited by, but not prohibited by, the US Constitution. Let's start with the monitoring programs. The federal programs go by the generic name of Einstein. Einstein 2 is an intrusion detection cybersecurity system fully deployed by the federal government in 2008 to protect the federal cyber networks. Its successor program, Einstein 3 of course, which is still in development as of late 2012, not only detects cyber intrusions on the federal network, but also seeks to actively prevent them. In the next iteration, these programs will be moved from the federal system and increasingly be deployed on private networks to protect critical infrastructure. And therein hangs our tale, and a constitutional issue worthy of consideration. Because these private networks are also the ones that you and I use every day to talk to our friends or to participate in political rallies. An intrusion detection system like Einstein 2.0 operates through what one might call a lookup system for spotting malicious code. Every piece of code is unique. It has what is known as a signature, essentially an identifying code component that serves as a marker for the program, like its DNA. Now, when we spoke about the problem of distinction in Lecture 3, we were talking about the difficulty of identifying malicious code. The problem, you may recall, is that when we first encounter malicious code, we can't tell that it's malicious. But eventually, with effort, the code can be identified as such, and its unique characteristics can be mapped. The detection program has a database of known malicious code signatures on file, and constantly compares incoming messages with malicious signatures. When it finds a match, it sends an alert to the recipient. For the federal system, Einstein 2 gets its database of malicious signatures from a variety of sources, including both commercial sources like Symantec, that's the private internet cybersecurity company, and classified sources at the US National Security Agency, or NSA. And for reasons that will become clear in a second, it's important to note that Einstein 2 is a gateway system, one that screens traffic as it arrives at federal portals, but does not stop any traffic at all. Einstein 3, the next generation of the program, is based on a classified NSA program known as tutelage and is different in several respects. First, its goal is to go beyond Einstein 2's capabilities of detection of malware and an alert to take the next step of actual intrusion prevention. After all, simple detection is a bit like telling someone you're being robbed after the bank robber is already inside the vault. It is naturally far more valuable to prevent the robber from getting into the bank in the first instance. To do this, Einstein 3 must intercept all internet traffic bound for federal computers before it's delivered, delay it temporarily for screening, and then pass it along or quarantine the malware as appropriate. Einstein 3 also adopts another less definitive and more probabilistic method of identifying malware, something different from the lookup malware check system we already have. This new system goes by the generic name of anomaly detection. In essence, the Einstein 3 program knows what normal internet traffic looks like and can produce an alert when the incoming traffic differs from normal by some set tolerance level. So if traffic is coming from an IP address that has never been used before, or if it's occurring in large volumes at odd hours, that might trigger an alert, even in cases where we don't have a malicious code signature to compare the traffic to. And for that system to be effective, the Einstein 3 screening protocols must reside outside the federal government firewalls, on the servers of trusted internet connections. As you might expect, for the federal government, these trusted internet connections are all operated by American companies. There's little real legal debate over the operation of Einstein 2 or Einstein 3 as applied to government networks. Almost everyone who's examined the question agrees with the conclusion reached by the Department of Justice's Office of Legal Counsel. It is appropriate and necessary for the government to monitor traffic to and from its own computers. After all, if any citizen sends a cyber transmission to the federal government, we can fairly presume that he wants it opened, and that if it is a malicious transmission, he has no legitimate interest in having it opened only in the way he wants it to be, so that it has a bad effect. Legal disagreement is much more likely to be over how deeply a government-owned and operated system such as Einstein, let's call it Einstein 4 if we want to, may be inserted into private networks, either to protect the government or to protect private sector users. The question is whether such a system would pass constitutional muster. Now, we should note here that in addition to constitutional questions, the full operation of Einstein 4 would require several amendments of existing statutory restrictions, amendments whose political viability is, frankly, highly questionable. Thus, while we begin with a discussion of the legality of the system, that doesn't mean we should lose sight of the related question of whether or not it's a good idea. Legal isn't always wise, and unwise isn't always illegal. But let's start with the law. To begin with, current doctrine makes it clear that there is a difference in the level of constitutional protection between the content of a message, the text of what it says, and the non-content portions, like the address on the outside of an envelope. In general, the non-content portions of intercepted traffic are not protected by the Fourth Amendment. That's the constitutional amendment that protects against unreasonable searches and seizures. The Supreme Court addressed these questions in a related context in two 1970s era cases, United States versus Miller and Smith versus Maryland. In both cases, the question was, in effect, does an individual have any constitutional protection against the wholesale disclosure of personal information that had been collected legally by third parties? And in particular, could an individual use the Fourth Amendment to prevent the government from using data it had received from a third-party collector without first getting a warrant? In both of these cases, the court answered with a resounding no. Along the way, it developed an interpretation of the Fourth Amendment that has come unsurprisingly, to be known as the third-party doctrine. One has no constitutional rights to protect information voluntarily disclosed to others. The reasoning is that by disclosing it, the data owner has given up any reasonable expectation of privacy that he might have had. So, the Miller case involved bank records. According to the court, financial information voluntarily disclosed by an individual to a bank is not protected by the Fourth Amendment against subsequent disclosure to the government. So if you, say, write a check to a doctor or a political campaign, and the government wants a copy of the check from your bank, there is, according to the court, nothing in the Constitution that limits how they get it. They can just go and ask the bank for it. That probably surprises you. Yeah. It certainly surprised Congress, so much so that they immediately passed the Right to Financial Privacy Act, which put limits back onto what law enforcement could do. Now, the Smith case, Smith versus Maryland, that was pretty much the same song, just sung in a different key. In that case, the court held that an individual's telephone toll records, that is, the records of the phone numbers called by the individual, were not protected against disclosure. If you're willing to tell the phone number you're calling to AT&T or Verizon, you can't, the court said, complain if they in turn tell it to the government. In effect, the court has adopted a gestational theory of First Amendment privacy. Not just as you can't be a little bit pregnant, you can't, according to the court, be a little bit public and a little bit private. What you disclose to anyone is fair game for everyone else. One of the oddities of these two cases is that they're both pretty old. They come from the 1970s, back before personal computers even existed, and back before there was any real reason to be concerned with the wholesale collection of personal information, a topic for our next lecture. It's pretty curious, in the end, to talk about privacy on the internet when the basic case law predates the Apple computer. Recently, in a case in January 2012 called United States versus Jones, the Supreme Court indicated that it might reconsider the third-party doctrine in light of technological changes. But it hasn't taken that step, at least not yet. So we're left right now with this old 1970s doctrine. In the context of cybersecurity and intrusion detection, the same result follows pretty easily. Non-content header information in internet traffic, like IP addresses and the to and from lines of your email and such, are not protected from disclosure as a matter of constitutional law. Because that information has been provided to your internet service provider, it loses any constitutional privacy protection it might have. And a government-operated Einstein 4 system is free to scan the non-content portions of the message for malware. This legal analysis, however, gets us only part of the way to an answer. The Miller-Smith rule does not, by its terms, permit the use of an intrusion prevention system to routinely scan the content portions of an internet exchange. Those portions, the actual messages themselves, remain private, just as telephone conversations are also private. As a result, a government program typically may not review those content portions of a message without probable cause and a warrant. To think of this clearly, just think of the difference between